This week, the country's apex court delivered a significant update in one of the country's most talked about legal battles, the Please Call Me case. It all began in 2000 when Nkosana Makate, a former Vodacom employee, pitched a simple but revolutionary idea, a service allowing mobile users to send a free message asking for a call back when they had no airtime. Vodacom launched the service, which became hugely successful. Yet, for nearly 2 decades, Nkosana Makate has fought for fair compensation, claiming the company owes him millions, if not billions, for that invention. The case has seen a back and forth through the courts with rulings and appeals that can be confusing for many South Africans trying to understand the legal process. This past Thursday, for example, the Constitutional Court sent Makate back to the Supreme Court of Appeal to reassess the case, adding another twist in this long-standing dispute. So let's try now and get to the bottom of this. I'm joined by Bophelo Seleke, who is an independent legal expert who joins us now to take that conversation forward. He's also my good friend. Good afternoon to you, Bophelo. So let's start with this. It was all quite technical, this particular judgment. It was, lawyers and experts probably had a field day in the sense of the legal questions that were being raised. But for the ordinary South African, I imagine that it can be confusing, because we expect that when a matter is at the Constitutional Court, it will have finality. In fact, people were betting and saying, how much will Nkosana Makate be entitled to payment? We end up with a case that says, referring it back and remitting it back to the Supreme Court of Appeal. What's your best answer to the question of why that happened and why the Concourt did not give finality to this matter?
Well, thank you, Tulas. The legal back and forth can be deeply confusing for the public, I do agree, largely because of how appeals and reviews work in South African law. Now, while the Constitutional Court is the highest authority, it does not always issue final figures or awards. What it would do, and what it has done, is instead it may refer matters to or remit matters to lower courts if it believes errors were made. And in this instance, the SCA will now have to reevaluate the amount that Makate should receive, of course, guided by the principles that the Constitutional Court has now clarified. And it really is a long and technical process, but this is how our legal system ensures that justice is not only done, but it's done properly and to an extent transparently to us.
But why are we still here, though, Bophelo, when the Constitutional Court decided a couple of years ago that Vodacom was bound by an agreement between its executives then in 2001 and Nkosana Makate, and therefore he was entitled to being compensated. And there was that whole process that was to ensue that would have involved negotiation, if that fails, a determination by the Vodacom CEO. So why is there still a debate?
We're here because in the latest judgment of the Constitutional Court, I think delivered on the 31st of July, it set aside a previous ruling by the Supreme Court of Appeal and had remitted, the matter back for a reconsideration. And the court found in the main that the SCA had misapplied the facts and overstepped its bounds by interfering with the compensation determination made by Vodacom CEO. But perhaps more importantly to us, is that the Constitutional Court reaffirmed that Makate is entitled to just and equitable compensation, and that this amount should be calculated fairly based on the commercial success of the Please Call Me service. And maybe to extend, it's also important to know that what Justice Madlanga had highlighted in what the SCA failed to do, one, had indicated that the reasoning of the SCA in the main were thinly reasoned and confused. But the justice was of the opinion that the SCA ignored key disputes, such as how long should Makate share in the revenue? Would it be for 5 years or would it be for 18 to 20 years? And whether 5% was agreed upon in the initial discussions that we got to learn about in the High Court, or that it was arbitrarily selected. The justices also were questioning how the SCA had failed to apply itself to the CEO's rationale behind limiting the incremental revenue and whether it was appropriate to average different compensation models as we would have spoken about.
So the other key element had to do with the Supreme Court of Appeal, in the view of the Constitutional Court, awarding Nkosana Makate what he had not even asked for. Explain that element for me, that element of a cross appeal that wasn't there, but which turned out to be successful.
Yeah, well, in South African law, a cross appeal allows for a respondent in an appeal to also appeal part of the judgment that they may disagree with. Now, even if the appellant in that instance is not appealing that specific aspect, but essentially a cross appeal would allow a respondent to seek a different outcome than what the original appellant would have been pursuing. Now, in the instance of Makate, the overlap of the SCA powers is that the justices were of the opinion that there was a substantial issue where the SCA had veered into terrain that it did not have jurisdiction in, and thus violating Section 34 of the Constitution, which is the right to fair hearing, and the rule of law, which is Section 1C. Now, that's where the question of the cross appeal comes in, and veering into jurisdictions that the SCA initially did not have.
Yeah. And in simple terms, does this relate to the SCA sort of awarding an outcome that basically substituted, rather than remit back to the CEO of Vodacom, but substituted that decision? Is that in essence what this cross appeal was about?
Well, you'd remember that in the SCA, a very peculiar reasoning was adopted in that the SCA had substituted, as you say, the reasoning of the CEO at the time and the compensation amount that had been arrived at. I think it was something in the range of 47 million. What the justices then had an issue with is quite plainly that the SCA in front of them had facts to which they could make a definite determination on what compensation and in what amount it needed to, Vodacom as the company needed to compensate towards Makate. Now, the vague and the largely unenforceable, in the view of the Constitutional Court, the view and the judgment of the SCA was that the 5 to 7% range that the SCA advanced in its judgment was largely inexplainable. It could not pin down to legal principles or commercial reasonings as to what the leeway for the SCA to pin its judgment on a compensation amount or percentage of between 5 to 7%. Thus, the question of the substitution.
So lastly then, Bophelo, I don't know, you have more experience in these matters than I do. The tone of the Constitutional Court in assessing what the Supreme Court of Appeal did, I found that to be quite extraordinary. The SCA is not your ordinary, I don't know, lower court. It's one of the superior courts, and actually in many instances it is the final, the buck stops here. Usually when you hear such a scathing judgment, you usually find it from the SCA itself, criticizing usually a high court and other courts below that. I thought that was quite extraordinary, talking about it being thinly reasoned, the judgment of the SCA, talking about it being confusing, and also basically what was the actual dispute was actually not even decided in this case. I don't know, am I reading too much into that, into the extraordinary tone of the criticism from the Constitutional Court to the second highest court in the country?
No, you're quite right. I think a lot of the conversations that had taken place as to what judges can and cannot do when faced with certain matters was probably, a right fit in as far as what Madlanga J in the judgment, in the unanimous judgment, in that the judges of the Constitutional Court, the justices, were communicating their frustration through the judgment. And perhaps one could see it as an admonition It could also, be seen as wrapping over the knuckles of the justices also at the SCA to say, but you had core legal questions that you had to answer. And it was an issue of just and equitable compensation in the absence of a formal contract. Don't veer off. And that when you do keep just and equitable compensation in mind in your judgment, how do you fairly value a simple idea in the context that we now know had generated billions over time?
Yeah.
But what was perhaps at issue, and what I read into the judgment, was the issue of discretion, the issue of how much discretion does a company CEO have in deciding compensation, and to what extent can the courts intervene? So the language of the Constitutional Court in this instance was very clear. In remitting the matter back to the SCA, it was saying, please reconsider these facts before a differently constituted panel, but here are now the guardrails that you must now use to aid you in arriving at a correct decision. Yeah. So one cannot simply ignore the fact that the SCA, the Constitutional Court, knows exactly how the judgment of the SCA ought to have been, what it ought to have said, and what it ought to have directed in its judgment, but it did not do so, hence earning the irritation or perhaps the ire in Matlanga's judgment.
All right, let's leave it there for this afternoon. Thank you for your time and your insights. That's Bophelo Seleke, who is an independent legal analyst, talking to us there about the situation and the outcome in the Vodacom versus Nkosana Makate matter that was before the Con Court.